Okay, good morning. I'm going to wait for my presentation to come up. Thank you. My name is Rob Williams. I'm a director of the Indigenous Peoples Law and Policy Program at the University of Arizona in Tucson. I am a professor of law and American Indian Studies. I'm also a member of the Lumbee Indian Tribe of North Carolina. And I want to thank the Assembly of First Nations and Grand Chief Atleo for extending this invitation to allow us to present this case. This case has attracted the attention, as Robert said, of numerous allies and supporters, including Amnesty International, the Assembly of First Nations Summit, and over 20 individual First Nations in Canada have filed amicus briefs. People within the international human rights system have said that this case has the potential to be the most important Indigenous land rights decision of the decade. That's not just for Canada, but that's internationally. I think the important thing to understand about the inter-American system is that many of the decisions which I'll briefly review today and developments were precursors to the development of the UN Declaration on Indigenous Peoples' Rights. In fact, the UN Special Rapporteur has recognized that the decisions of the Inter-American Commission are part of the foundation of modern Indigenous human rights laws reflected in the Declaration. I began in 1999 when this case, in another form with another group of First Nations in BC, when I gave a talk at the University of British Columbia on the sovereignty model of U.S. Indian law. And we were there with the Navajo Supreme Court, and we were talking about the unique aspects of tribal self-determination under U.S. Indian law, and wouldn't it be great if Canadian First Nations could have the same type of powers? After that talk, a chief came up and said, you know, we're very interested in that sovereignty model, the model that Canada is presenting to us under the comprehensive claims process under the British Columbia Treaty Commission really doesn't have a sovereignty model. They want to turn us into a municipal government subject to Canadian laws. And she said, would you help us? And I said, sure, I'll get my law clinic. At the time, I was teaching Indian law in a winter course at Harvard, so I got 6 very bright Harvard law students. We took the Nisga'a Treaty, and wherever it had the province in, we just deleted that. And wherever it had delegated powers, we replaced that in all 20-some chapters. We went through all 20 chapters and just totally revised the treaty to reflect the sovereignty model. The First Nations groups presented it before the BCTC Commission. They tabled it. And a week later, the chief called and said they weren't very happy with that sovereignty model. I go, what do you mean? He says, well, they suspended treaty talks and they allocated all the remaining timber cells we have to 8 different timber companies. Now what do we do, Professor? And so I went to my colleague, Professor Jim Anaya. Some of you may know him as the present holder of the United Nations Special Rapporteur on Indigenous Peoples. He is my co-founder of the program. And Jim had brought many of the major precedents in the international human rights arena, advancing the cause of Indigenous peoples' territorial rights. He had been lead counsel. I had worked with him as well on the Awastini case in Nicaragua. He had brought the Belize case involving the Maya before the Commission, a number of UN CERT activities. He said, well, why don't you file a human rights complaint? So we filed a petition with the Inter-American Human Rights System, and we were granted admissibility. On the morning of the hearing, 5 of my 8 chiefs came to me and said, we don't want to go forward with the hearing. Canada contacted us last night, the Ministry of Forestry, and offered us 500,000 board feet of timber cut if we would drop out of the case. I said, well, that's how they do it up here. so for them, and we had a long talk, and for them, that was, you know, how the human rights process worked for them. That's what they wanted. They wanted those opportunities for economic development, and we said, fine. We worked with First Nations Summit. I want to give a special recognition to Ed John, who encouraged our program to keep bringing this case. And I met Robert at another conference. Every time I go to a conference in Canada, it looks like I get a case. And we brought this petition. I do have a funny story. I remember it was Jim who helped me develop this petition in 2007. And I remember soon after we wrote the petition, I had to call legal counsel for the Attorney General of British Columbia and also the Department of Justice in Canada. And I said, I have an important announcement to make on a conference call with respect to our petition, and I'd like to speak to you about it. And when I got on the phone, I said, I have good news and bad news for Canada. And they said, well, what's the good news? I said, well, the good news is for Canada that the person who's really, one of the architects of modern indigenous human rights law, who's brought all these landmark cases protecting and advancing the human rights of indigenous peoples, who helped me draft this petition, has had to drop off the case, Jim Anaya. And I could hear them chuckle, and they said, oh, that is good news. What's the bad news? I said, the bad news is he's just been named UN Special Rapporteur for Indigenous Peoples, and he's going to be all over your case. So we proceeded with this petition. Basically, as Robert said, this you can see in the outline yellow. This is the traditional territory of the Hul'quminum on Vancouver Island, outlined in yellow there. In 1884, Canada, in all the area in green, basically gave all that property to the ENN Railway Corporation to construct a railway for the civilization of the rest of Canada. They then took the Gulf Islands from them in subsequent grants. And so with respect to their original territory, these were the reserves that they had left. Can you see them? The little pink spots. Today, all the area in color is either owned by 3 large private forestry development corporations or by local governments. So you can see the unique situation confronting the Hulquminum. All their territory is largely 85% private lands. Very little crown land has been one of the major stumbling blocks in the BCTC process. And you can see what happens on those private lands. We got a helicopter. We flew over the lands of Timber West Forestry Development Corporation and the other, what we call the big 3 forestry companies, and took hundreds of pictures and submitted a number of those pictures and evidence to show what happens on private lands in Canada, which go unregulated by the government. And so we requested 2 specific remedies. And what I want you to do is pay attention to just how different the language is. I'm going to be talking a little bit later today on the self-determination panel on the way we talk about indigenous rights. And coming from the United States, quite frankly, I'm amazed at the discourse of indigenous human rights here. It's totally dominated by Canadian law. And so we talk a much different discourse under indigenous human rights. And that's what I'm here to try and help you understand today. What we are seeking is recognition of the Hulquminum indigenous peoples' right to property in their ancestral lands, including lands in private hands, by setting boundaries, demarcation, and by recording of title. The case law and the precedents of the Commission and of the Inter-American Human Rights System have said that the state has an absolute obligation to demarcate and grant title, recognized title, to the ancestral territories belonging to indigenous peoples, even when they're held in private lands. And then the state has to work it out. And until that happens, and this is what is so important, until that happens on those private lands, the state must implement a process of prior consultation for the purpose of preventing the destruction of the environment. So that picture I showed you with the clear cutting, that is clearly a prima facie violation of the American Declaration. And so until that process of effective consultation is in place, the state cannot allow destruction of the traditional lands of the Hulquminum. Now, briefly, let me set that in the context of the Inter-American Human Rights System. So we're asking for 2 very simple remedies. And I want you to know that we filed this case in 2007, and in 2009 we got an admissibility decision, 2 years. Some of you, I know because we've briefed all these cases, have been involved in litigation for 20 years. This is a highly effective forum. It is not legalistic. It allows a wide latitude for introducing evidence from indigenous elders. It allows a wide latitude for amicus briefs. That's why we brought in all those amicus briefs, and the Commission looked at them. Okay. So, how much? Okay. So basically, the two major provisions that we look at are Article 2. The Declaration promises indigenous peoples the right to equality. And then Article 23 promises indigenous peoples the right to private property. And the Commission has held that if the state recognizes the property rights of white people but doesn't recognize the traditional property rights of indigenous peoples, that's clearly a violation of the right to equality and is a violation. We brought this case before the Inter-American Commission. It's comprised of 7 experts, independent experts. And the first phase involved Canada's argument that we couldn't go to a human rights body. We had to go before Canada's domestic legal system and use either the BC treaty process or Canada's courts. And after 2 years of arguments, this is what the Commission held. Since 1994, HTG, through treaty negotiation process, has sought to brought to the attention of official authorities the central facts contained in the petition. And the Commission found that at that point, in 2009, it had taken over 15 years in the BCTC process and nothing had happened. And the Commission has basically found that anything less than 3 years is an ineffective remedy. So how many of you have been involved in treaty negotiations for 3 years? How many have been involved in treaty negotiations for 15 years? How many for 20 years? The Commission has clearly found that Canada's comprehensive claims process is an ineffective remedy. The second point that the Commission found involved Canada's domestic judicial system. And the Commission there found that, again, based on the evidence presented by over 20 First Nations, the Hul'qumi'num tribe, the tribes involved in Delgamuks, all filed amicus briefs explaining their difficulties in securing their rights. And I think what probably is the most important legal precedent and historic precedent, one which I think you all need to know, is that an international human rights body to which Canada has treaty obligations has found that Canada's legal system cannot provide an effective remedy for your property rights. Why are you wasting your time? So in conclusion, having gained admissibility, we now are fighting at the merit stage. And our claim involves basically 2 important points. Now that we've established that Canada does not have any effective remedies to protect Hul'quminum rights, we are asking the Commission to direct Canada to demarcate and title the property of the Hul'quminum people. And in the absence of that, until they do, to implement a regime of prior informed consent, because the Commission's jurisprudence is absolutely clear that where private parties are destroying the ancestral territories of indigenous peoples through activities like clear-cutting and mining, the state has an obligation to engage in fully informed consent. That, again, is not a right recognized under Canadian law. So in closing, I think the big point that's been reported in the press, and I'm asked a lot by indigenous peoples, not only here but throughout the inter-American system, is, well, is this binding? Is this legally binding? And as Robert explained, Canada signed on to the OAS in 1990, and in signing on, they took on the legal obligations to conform their domestic legal system to the principles of the American Declaration. Those principles require Canada to recognize your right to property no matter who owns it, and then finally to engage in prior and effective consultation and consent where activities of third parties destroy those lands. And so Canada has a legal obligation. And I'll leave you with this question, and it goes to the heart of the matter. If the Commission issues a decision in Hul'quminum Treaty Group's favor, and Canada decides not to abide by its treaty obligations to 23 sovereign nation states in the Western Hemisphere, Canada has treaty obligations to the United States, to Brazil, to every nation in the Western Hemisphere. If Canada will not listen to the Inter-American Commission and its interpretation of the Declaration, if Canada will not honor its treaty obligations to the Inter-American human rights system, why would it bother honoring its treaty obligations to you under the comprehensive claims process? Thank you.